So you just don't like the music, but they create music, right?
Okay, listen, Mr. McClyment, listen. And I'm looking at the statute here, and I'm looking at the most recent version. And this is the one that was effective February 13th, 2025, correct? That's the most recent version you guys are aware of?
I'm trying to pull it up on Westlaw right now.
I'm looking at it right now. This is what Westlaw shows to me. This is the most recent version. And it states at 907-041 5K.
That's the pretrial detention. Are you talking about the gang statute or the pretrial?
No, I just want to get us focused on what I'm going to be considering. That's why I'm backtracking on this. Okay. So I'm looking at 907-041, the version of the statute that was effective February 13th of 2025, subsection 5K. Quote, a party may motion for a pretrial detention order to be reconsidered at any time before a defendant's trial if the judge finds that information exists that was not known to the party moving for reconsideration at the time of the pretrial detention hearing, and that such information has a material bearing on determining whether there are conditions of release or bail that will reasonably assure the appearance of the defendant as required and the safety of any other person and the community from harm. So that is the standard I will be applying. So all of this stuff, all of this historical stuff about ATK and all candor is not going to move the ball. You need to ask this witness about anything that has occurred since that either wasn't known at the time of that hearing by counsel representing your client, or something that has changed subsequent to. Okay.
So I guess two issues. I think you mentioned that was from February of this year.
Yes.
They make laws after that, the legislature. And
I know, but do you have the more recent version? I'm just looking at Westlaw, and I'm just telling you what Westlaw is showing me, that the most recent version is February 13th of 2025.
I mean, I can show you what I have. I'm not sure what you're looking at, but I can show you what I have.
I'm looking at Westlaw. That's what I'm looking at. 907.041. They have this as the most recent version. If I'm wrong.
And Judge, that's what I had made representations to the court as well. Like, I had looked at all versions, and the latest one had just moved it to a different letter.
Okay.
But the state cited a whole different subsection, so that wasn't the latest.
I know, but are you, as an officer of the court, are you telling me that whatever it is you're relying upon as far as it being the most recent version of the pretrial detention order, are you telling me that this language no longer exists? Is that what you're telling me? That's what you're telling me.
Yes. So I can show you my computer right now, the LexisNexis.
Well, do you have can you print it up?
I didn't print it.
Okay. So at this point, Mr. McClyman, we're not just going to go back and completely reopen all of the testimony from the first hearing. That we're not going to do that. So I need to hear about anything that wasn't known previously, or something has changed as far as a situation that has changed since the hearing that would require me to reconsider Judge Sabella's ruling. So that's what you're asking me to do, is undo something from a previous judge.
Oh, well, I filed a motion that has two components to it: an Arthur hearing request and a request to reconsider the pretrial detention order. If I'm asking you to reconsider the pretrial detention order, and if the statute that the state is relying on says what the court is saying, then I would have to go into that framework. For my Arthur hearing, I don't have to show any change in circumstance. I'm traveling under a completely different procedural rule, 3.131, and the first sentence in Article 1, Section 14. So I don't have to show this change in circumstance or anything like that for the Arthur hearing. That's what I asked for.
I know, but Judge Sabella entered his order. He didn't even address Arthur.
But that's the point. That's why I'm having the Arthur. That's why we're having the Arthur hearing now. She's still entitled to an Arthur hearing.
But I tell you what, let's deal with 907.041 first. And then if need be, we'll get into the Arthur factors. But I'm not going to relitigate all of the facts that were elicited at the pretrial detention hearing. We're not relitigating that. I'm just telling you right now, we're not doing it.
All right. So I guess I can ask my questions. My questions are geared towards both issues, the Arthur hearing and pretrial detention. But if I'm only allowed to ask questions as to the pretrial detention, then
of this witness, let's stick with this witness. Okay. And so far, what you've asked him about is his knowledge of the ATK gang. All I really want to hear about from this witness is if something has changed, if there's something about the ATK gang that was not known at the time of the original pretrial detention hearing, I'd like to know about that. If there's anything that's changed since this hearing about the ATK gang, whether in fact it's a gang or not, I would like to hear about that. Other than that, it's irrelevant.